So, welcome everyone. So, today we will be starting our new topic that is in relation to the presumptions that are taken by the courts regarding particular document. So, basically, there are two types of presumptions. First one is the of mandatory nature, that is the shall presume, which is defined under section 2L of this adhiniyam, which states that the court is duty bound to presume that a particular document or any particular fact exists. So it is the duty of the court. And another one that is of optional nature, which is defined under section 2H of this adhiniyam, that is may presume. So that is in relation to the judicial discretion of the court regarding taking any presumption in relation to a particular fact or any particular document. So basically there are two types of presumptions. First one is shall presume and another one is may presume. So after that, after clearing the types of presumptions, we will be discussing one by one the particular and different types of presumptions that are being taken by the court where the word is may. So that will be covered under section 2H, that is of optional nature, and where the word shall is used, that is a mandatory presumption to be taken by the court. So presumption means कोई फैक्ट या डॉक्यूमेंट की जेन्युइननेस को सही मानना. So court presumes on its own without considering the evidences. So but the party against whom presumption is taken has right to produce documents or evidences, other evidences, to rebut that presumption. So there is a difference between conclusive proof and presumption, where one fact is declared to be a conclusive proof of other fact. If one fact is proved and then other fact is considered as conclusive proof, in that situation the party against whom the conclusive proof is proved, that is not allowed to give any particular evidence or document. So there is a bar. So the two types of conclusive proofs that we have already studied, that is under section 35, which deals with the character in relation to probate, admiralty, and matrimonial cases and insolvency cases. So where the court has given particular character to a person, so that character will be of a conclusive proof. So the party against whom character is being labeled will not be allowed to give any particular type of evidence or any particular kind of any document to rebut that conclusive proof's nature. But that is not in the case of presumption. Presumption means any fact or any document which is considered by the court by its own, but against whom the presumption is being taken is allowed to give any evidence to rebut that presumption. So there is a difference between conclusive proof and presumption. And after that, further, the presumptions are of two types. First one is shall presume and another one is may presume. So shall presume is of mandatory nature and may presume is of optional nature. May presume, the court applies its judicial mind whether to take that presumption or not. So it depends upon the sole discretion of the court. So let's start with the various types of presumptions that are being given by this adhiniyam, starting from section 78 and it goes till section 93. So you have to just learn all these presumptions regarding particular documents. Section 78 deals with the shall presume, that is of a mandatory nature. Presumption in favor of certified copies. So any certified copy given by a public servant under section 75 of this adhiniyam will be considered as genuine. It is shall presume. So the court is duty bound to consider that the genuineness of that certified copy. But the other party against whom presumption is being taken is allowed to rebut that presumption by giving any particular type of evidence or any other testimony of any witness. So Here, so genuineness of that certified copy will be considered. What will be included in that? The particular public servant who has given that certified copy, the court will presume that that public servant was under the power, and the seal and the signatures on that certified copy will be presumed to be correct. But the other party has opportunity to give evidences to rebut that presumption. So 78 deals with the presumption of genuineness of certified copies which are given by a public servant under section 75. So that's all under section 78. And section 79, that is most important, which gives presumptions to the documents produced as record of evidence under court. So any evidence or any testimony which is being considered in a court will be presumed to be correct. So for example, uh, any statement or any kind of confession recorded by accused under section 183 of Bharatiya Nagrik Suraksha Sanhita. So we will discuss in detail regarding what are the conditions for a confession under section 183 of BNSS. So as of now, so it is being recorded by judicial magistrate in presence of accused. So accused gives confession to a judicial magistrate. So there are some conditions before that. Some conditions include that the judicial magistrate has to ensure that the confession's nature must be voluntarily, and along with that the accused must know that the confession he is giving before that magistrate will be used against him in a trial as evidence, and that can lead to conviction. So these are the special conditions for recording a confession. So when confession is being produced before a court, so the court will presume that all the conditions and all the prerequisites are being fulfilled by the particular officer. So section 79 deals with the shall presume regarding the record of evidences being produced before a court. So after that, section 80, that is also a shall presume presumption under section 2L, that is of mandatory nature, and that deals with the gazettes, newspapers and other documents which are released by the government. So as the genuineness is in relation to the form of that particular document and how they are kept. So the court will presume that the documents which include gazettes, newspapers and other documents released by the government will be correct. Their form is correct and they are being kept in a substantial form that is being correct. So the genuineness is in relation to the form and substance of the document. So after that, section 81, that is corresponding to section 80, and given the legal recognition to the electronic records. So if any gazette, if it is in the form of digital record, so same thing goes for electronic record. So the court will presume the genuineness of that electronic record or digital record which is in the official gazette of the government. So nowadays the e-governance is in prevalence, as the Information Technology Act 2000 also gives recognition to the government for the e-governance. So most of the policies and most of the other schemes of the government are being released in electronic form. So the court will presume that all the electronic records, which includes the policies and other schemes of the government, so the court will presume that all the electronic records in relation to those policies and the schemes will be correct. So here, the other party against whom the presumption is taken, he is allowed to rebut that presumption. Section 82 deals with the presumptions in relation to maps or plans made by authority of the government. So as we have already studied under section 30 of this adhiniyam, any map prepared by the government is a relevant document in relation to any case or any scenario. So the court shall presume the maps or plans prepared by the authority of any state government or central government, that those maps are accurate. So the genuineness is in relation to the accuracy. The presumption is in relation to the accuracy of that maps being prepared by the authorities of state government or central government. So after that, the presumption is in relation to the laws and reports of decisions. So any collection of laws, any books, or any report of decisions. So suppose all India journals which record the all the judgments, important judgments of Supreme Court and various high courts. So the court shall presume the genuineness of that collections of laws and every judicial decision, that those laws and the judicial decisions are printed and published by the authority of the government are correct. So there is a presumption in relation to the correctness of laws of the country, and along with that judicial decisions which are being printed and published by the authority of the government. So the court will presume that all the decisions and laws printed by the particular authority are correct. So we have completed 3 4 5 6 type of presumptions that are in relation to mandatory nature, shall presume. So tomorrow we will be discussing the other remaining presumptions, some may presume and other kind of presumptions in relation to documents and electronic documents. So as of now, you just have a quick look at all the presumptions. So we will be starting and completing all types of presumptions tomorrow.